Hi, everybody. I hope everyone can see me and the PowerPoint presentation. If you cannot, please message Stephanie and I. Stephanie will be my co-pilot. Ha ha ha, I'm sure Adam or someone has already used that joke. But Stephanie will be here helping today if we have any technical difficulties. She's out of probably your view, but not out of mine, thank goodness. So if you have any problems hearing me or seeing me and the screen, please just send a message and Stephanie will let me know. Well, thank you for joining us today. I am the third installment or the third flight in our webinar series, and I'm going to talk today about retaliation. And we've talked about this a lot, I know, in past seminars, and it seems to be a relevant topic all the time. And the reason being is that because we see plenty of retaliation complaints. Not just discrimination complaints, but retaliation usually accompanies it. And so today I'm going to talk about 8 particular types of personalities that you all have probably seen in your workplace and how to deal with those personalities when they are presenting a certain type of complaint and whether that complaint is a protected complaint under the law and how you should handle it. So let's get started. I'm Tanya Bryant. I am a shareholder and director in the Labor and Employment Department in our Oklahoma City office of Crow and Dunlevy. And I must tell you that this presentation is not legal advice. One thing that, that would occur if it was legal advice is that I would be talking to you for probably hours on end and getting specific facts from you and documents and all sorts of other things that may change or alter any professional advice that I were to give. So this, of course, is not legal advice, and we will move ahead. All right, so who is protected under the law? So nearly every employment statute has a non-retaliation provision. I'm not going to read these all off to you. Most of you all know or have at least heard of these statutes. The one that we see most often is Title VII, the ADA, the ADEA, and FMLA. And then sometimes OSHA and Equal Pay Act. I've never seen a Polygraph Protection Act one, but yeah, you never know. Additional laws that have anti-retaliation provisions in them are listed below there. The NLRA, that's something that we'll talk about later on today, and also the Oklahoma Anti-Discrimination Act also has an anti-retaliation provision. All right, elements of retaliation. So what I'm going to do is I'm going to go through these initial slides with you to give you a background. I know many of you are familiar with this already, but I'm going to give you a background of what we're going to talk about, and then we will apply these elements and defenses and facts to the 8 personages that I've chosen to talk to you about today. Okay, so elements of a retaliation claim. The employee must have engaged in protected activity, which means they had to have made a complaint that complained of illegal conduct. The employee suffered adverse employment action. We'll talk about what an adverse employment action is. Most of you probably are already thinking termination, and that's typically the employment action that someone is complaining about in one of these claims, but it can be a different kind of action as well. And then, of course, the employee has to prove that there's a causal connection between the protected activity and the adverse employment action. One thing that I hear very often from clients is that, look, we did not we did not do anything illegal. And that's typically the case. There was nothing illegal done. It's the employee's perception that something illegal was done. Sometimes it's an outright just falsity that they just made up, but sometimes they believe that the employer's conduct actually violated the statute. So what I tell clients is that just because the actual illegal conduct did not occur, that doesn't mean that the employer automatically wins, unfortunately. So you have to go forward in the lawsuit in order to defend against the claim, even though there wasn't any illegal action. The focus of the claim is going to be on how the employer's reaction was to the protected complaint, if indeed it was a protected complaint. Protected activity. Okay, so, and we'll talk about this with our 8 folks. Not just any complaint will suffice. The employee must have engaged in protected activity. And what was it that the employee complained about? That's very important in order to draw the line between illegal conduct and legal conduct. Adverse employment actions. We already mentioned termination. Some additional adverse employment actions are suspension, reduction in hours or pay, denying a raise, deciding not to hire someone, demotions, and you see the rest of the adverse employment actions there. What's not an adverse employment action, and we will, like I said, we will talk about this here in a little bit, are vague or isolated remarks. And we'll talk specifically about examples of what those are. And then also contesting unemployment compensation. So unemployment compensation it's a benefit that the state, the Oklahoma Employment Security Commission, grants to a former employee, sometimes an employee. It just depends on the situation. But so it is a state benefit. So the fact that an employer is contesting unemployment, that would not be considered an adverse employment action because it's not the employer's decision whether the person actually receives unemployment. And Stephanie, I believe there are a couple of questions. You can see those. And what I would like to do is, so that we use our time as wisely as possible, is I'd like to take the questions at the end of my presentation. I've allotted some time. Hopefully we'll get through in order to be able to answer most of your questions. So hang tight and we will get to those here in a little bit, but Stephanie's going to let me know if anyone has any issues with the technical aspect of the presentation. All right, not adverse employment actions. Okay, questionable adverse actions. So we look at case law, of course, as attorneys, and so sometimes a negative performance evaluation can be an adverse employment action. These really turn on the facts. Transfers to another position. You see threats and hostility there. That doesn't mean, threats doesn't mean like a threat of physical violence. That would be horrible, but threats of discipline, that sort of thing. Hostility, just being mean, and also snubbing. And we'll talk about that, how that fits into whether it's an adverse employment action or not. The causal connection, what the employee has to prove in order to link the termination or the adverse employment action to the protected complaint they made, because that's ultimately what they have to prove. And so courts often look at the timing. And so you may ask one lawyer, does timing matter? And one person will say, timing is everything. And then another lawyer will say, well, timing's not everything. Well, it really depends on what jurisdiction you're in. And We will talk about in our examples some timing issues that would be problematic, and then some timing issues that may not be so problematic. And the reason I am including the causation requirement, because really this is, you know, it's a legal theory, or it is a standard of proof. And the reason I'm giving it to you or telling you about it is because retaliation is harder to prove in court than, let's say, a discrimination complaint. Discrimination complaint, you have to show, or the employee has to show that the employer's decision to terminate their race or gender was a motivating factor. Retaliation is different. Retaliation is but for. So in a retaliation case, the causation or the plaintiff would have to prove, but for their complaint, they would not have been terminated or suffered that adverse employment action. So it's really a higher standard. The FMLA, so far, its anti-retaliation provision does not have that but for standard, so it's easier to prove, or not as difficult to prove FMLA retaliation as it is to prove retaliation under Title VII and the ADEA. And I always want to throw in the plaintiff can use direct evidence or circumstantial evidence to prove causation. I think the easiest way to explain this is what I learned in law school was the professor said, okay, let's say you are in your house and you go to sleep. And before you go to sleep, your grass is green and it's cold outside, but that's, everything is just normal. And then you wake up and there's snow on the ground. Well, that is circumstantial evidence that it snowed because you didn't see it snow, but it had to have snowed because there was not snow on the ground before you went to bed, but there was snow on the ground when you woke up. And then, of course, direct evidence would be you staying up and watching that snow. So that's kind of an easy way to explain direct and circumstantial if you didn't already know what the differences were. Okay, whistleblowing, close cousin of retaliation. What we see in Oklahoma as employment defense lawyers are what's known as Burke-Tort whistleblowers. And those are employees that have made a complaint that the employer either engaged in illegal conduct that's against Oklahoma's public policy, or that the employer conditioned their employment, the employee's employment, on participating in that illegal conduct. So there are some whistleblower statutes. There are federal statutes, state statutes. Like I said, the Burke-Tort would be a violation of public policy common law. If you work for the state, there's the Oklahoma Whistleblower Protection Act. There is a provision in there for state employees. And for whistleblower, for proving a violation, the employee, of course, has to have engaged in statutorily protected conduct. The employer had to have taken an adverse employment action. And of course, that adverse employment action was a direct result of the protected conduct. So how should employers react when they receive a complaint? And I know you guys receive all sorts of complaints, ranging from minor to major. So we're going to talk about some of those. But before we do, I want to talk about some actions that employers might take, thinking that they are doing something good and helping the employee, when in fact it may be harming the defense of the employer in the event the employer gets sued. So as the old adage, no good deed goes unpunished. That happens sometimes in retaliation situations. And an example of that is, so you have an employee that is alleged sexual harassment by a supervisor. And let's say the employer wants to get that employee out of that environment ASAP. And whether it's because there's not another supervisor on that shift to take over for the supervisor, or the supervisor can't trade with another supervisor for, I mean, it's got to be a really good reason, or some other reason, the employer may believe that transferring the complaining employee might seem like the safest way to keep that employee away from the supervisor. However, that would be viewed as a retaliatory action. What the EEOC and the courts will look at is what action the employer could have taken with regard to the supervisor. Could the employer have put the supervisor on leave and brought in another supervisor, on leave while the investigation is underway? So those are the types of things that employers really need to consider when they are faced with a situation where they need to, separate an employee and their supervisor or two employees, to really be careful on how the complaining employee is treated. And we talked about this a little earlier, shunning or the cold shoulder. So, it's human nature to not be very happy when someone makes a complaint about you. And if there is a supervisor who has been accused of discrimination or some other action, and that supervisor, is afraid now to be around that employee, he or she might think, the employee, if I don't say hello to them in the morning, then they're going to get mad and say I'm, shunning or giving them the cold shoulder. If I say hello to them in the morning, then they're going to say I said it, in a snarky way or a mean way, or, so it's a very tough situation for any person to be in. And the best advice that I can give is for the supervisors to be, for this to be discussed with supervisors or whoever the alleged discriminator is, you really have to act as if nothing has happened. I mean, everything is as normal as can be, no overly nice, but just an everyday, day at work. And that's really, really difficult to do, but it hopefully will stifle any complaint about, being shunned or given the cold shoulder. Here is another situation that sometimes comes up when there is an investigation underway. So, investigations are confidential, and the employees should be told, or the complainant and the person who the claim was made against should be told that the investigation is confidential, and the employer will keep the information as confidential as possible. But I would not make any representations that the complainant will receive or the alleged discriminator will receive 100% confidentiality, because that is almost impossible, because you have to talk to usually other employees and coworkers of the complainant, and so it's hard to keep the investigation 100% confidential. Also, the EEOC will look at an employer instructing non-supervisory employees not to discuss a pending claim with an employee that's may just be saying, hey, will you go talk to HR and give them a statement, tell them what you saw. The EEOC will look at that as unlawful retaliation, and of course the plaintiff's lawyers will argue that as well. So how on earth do you protect yourself? Well, first, make sure you have that policy, and I'm sure most of you do, a policy prohibiting retaliation. It's included or should be included in your anti-discrimination, anti-harassment policies. You've got to really adopt those policies, give life to those policies, communicate what they mean to employees, and then also train supervisors. Do this, of course, in 2 different training courses, because the way that you would train employees versus the way you would train supervisors, of course, is going to be a bit different. So you want to make sure that you really give some teeth to those policies and enforce them when they are broken. Like I said, keep the complaints as confidential as you can and take the complaint seriously. Additionally, take disciplinary actions pretty promptly. One thing that we see sometimes, and we know that supervisors, especially frontline supervisors, they're really busy. They kind of set things aside sometimes and say, I'll get to that later. And then next thing you know, there's been a complaint and there's no disciplinary actions. So we'll talk about that issue and how to remedy that here in just a little bit. Also, once you have an employee who complains or blows the whistle, you really want to slow down, probably call your employment counsel, and really think about how to handle that particular employee. Make clear that your organization, your company is committed to eliminating fraud and abuse. So if you have a whistleblower, there's usually a policy or a hotline that addresses this. And then if you don't have a hotline, it's a good idea to have multiple avenues of complaint, not just supervisor or HR. And if they go out of some employers have a chain of command, and if an employer steps out of that chain of command, then their complaint is kicked back. I caution employers who have that type of policy, because that's not how a court or the EEOC would look at it. The court or the EEOC would look at the employer's policies as, they could have complained to the supervisor, they could have complained to HR, they could have called the hotline if they thought the supervisor, wasn't going to handle the issue. So it's important to have different avenues of complaint. Also, and we preach this all the time, document, document, document everything. Okay, before we go on to the 8 personages, I just wanted to show you this lovely little quote because it sometimes is relevant in employment law retaliation cases. All right, the 8 problematic personages. All right, let's start with good old Toxic Tom. So, and if your name is Tom, I apologize. And if any of these names or any of your names, I'm apologizing in advance. I just chose them because they started with T. All right, so Toxic Tom, he just hates everything. He's very critical. He's passive aggressive. He talks over people. He's abrasive. Maybe you know a Toxic Tom. Maybe there's a Toxic Tom in your workplace. So in this situation, I'm going to look at my notes here. Tom is a 63-year-old supervisor, and Tom has had complaints against him by his subordinates and by his peers basically about his toxic personality, that he's just very critical, abrasive, and just is always blaming others when things are sometimes his own fault. So Tom, on the other hand, also has a problem with some employees, and he has made a complaint to HR about millennials. He said that millennials are lazy losers, and he is tired of having to deal with them. So Tom goes to HR about the millennials, and some of his subordinates and some of his peers have gone to HR about Tom. Now, Tom also says that he is also being treated more poorly than the millennials because he's an old guy and they're younger and they're getting treated better. So here what we have is a protected complaint by Tom because he complained about being treated more poorly than the younger folks in the workplace. Now, the complaints that are made by the subordinates really just go to Tom's personality or his supervisory style. So those complaints in and of themselves would not be a protected complaint. So dealing with folks like Toxic Tom. Well, I would hope that in the past, if Tom had violated any policies, I'm sure that this company that employs Toxic Tom has some conduct policies, not just disciplinary policies that address poor work performance. And here he actually is a poor performer. So Tom's boss should have addressed that as well in performance evaluations and disciplinary actions. But Tom, who has been very abrasive to subordinates and peers, should have some disciplinary actions in his personnel file that can be used and reviewed before any action is taken with regard to Tom. So the company, after doing its investigation, has had enough, and Tom's getting fired. So the timing here, though, is 3 weeks. And Toxic Tom complained about essentially age discrimination 3 weeks prior. That is very close proximity. So in the legal realm, 3 weeks would be so close that a court would probably find an inference of discrimination. Now, Tom still has to connect the dots if he sues that the reason he was terminated was because he made that complaint. But for making that age discrimination complaint, he wouldn't have been fired. Well, the employer here had its trail of disciplinary actions, and after the last investigation into the subordinates and the peers' complaints, their complaints were they were substantiated, and so Tom's termination was then effectuated. So in this type of case, the key here is the prior documentation of Tom. And, you know, the key to dealing with folks that are like Toxic Tom is, you know, you can't change someone's personality, but you can make sure that they understand the policies and that any violations of those policies are going to result in disciplinary action. Now, I know a lot of folks say in their responses, and rightfully so, that Tom is just going to get more toxic with more disciplinary actions. But maybe Tom shouldn't be working there if Tom is not improving. So let's move on to Martyr Mary. Oh, Martyr Mary, she's just saving everyone from themselves. Mary is just the self-imposed victim. She never says no. And of course, she exaggerates her workload. Everything she is doing, if she wasn't doing everything for everyone else, she would not be so tired. It's everyone's fault that she's just exhausted. So Martyr Mary, you may know a Martyr Mary as well, or have, you know, met one in your HR life or even pre-HR life. So with Martyr Mary, this is probably one of the most difficult personalities to deal with. And I say that because it is innate in this person that they have this need to be seen as the martyr. They're a victim, but then they're coming to everyone's rescue, but then they complain about it. So it's a really hard personality to deal with. But in this case, we're going to talk about the complaint that Martyr Mary made. And so in this scenario, Martyr Mary is a nursing home worker. And, you know, nursing homes, just like hospitals, I mean, they're pretty darn busy all the time. And no matter how well the company is at staffing, there's usually someone complaining about staffing. Well, Martyr Mary is the one at this nursing home. And she's complaining about not only understaffing, but unsafe practices, unsafe patient care, and she complains all the time. Not necessarily marching into HR or to the DON's office or, you know, or to her charge nurse or whomever, but she is just constantly complaining. It could be to patients or residents or, you know, to anyone. But she has let management know in an informal way about these complaints. So Mary complains so often that no one's listening anymore, because the employer has checked their staffing. You know, sometimes people call in, and that just happens in these types of workplaces. And if the employer does their best to get someone to take that person that calls in, or I think now it's called call out. And sometimes there are just situations where it's just busier time than others. So the advice to the employer here, or the non-advice, is to meet with Mary. Meet with Martyr Mary. You understand her, not her plight, but you understand where she's coming from, and talk to her or listen to what all of her complaints are. And if you can address them at that time, then address them at that time. But also, if she's making, complaints that there's such as understaffing, get times, dates, people, so that you can advise her that you are checking into her complaints and will get back with her. And if she can write a statement, that would even be better. This forces Martyr Mary to write down what she has, what she is complaining of, what she says that she has seen and experienced. And when you put someone to the task of doing that, typically it's not as bad of a situation as they say. Sometimes, of course, there are exceptions, but typically not. So if Martyr Mary does not want to write a statement, that's perfectly dandy with you. Then you can take down her complaints, or the employer should take down her complaints and, write them, note them, and have her look over what you've written. Say, is this the extent of them? Hopefully she'll say yes. Do you want to initial here, sign here? Write her name and date it and ask her to sign it and say, look, we're going to get back with you on these. We appreciate your coming to us. Our door is always open, and we will get back with you. And then when you do look into the situation, and I do stress to investigate the situation, because oftentimes the complaint has been made so many times that the employer just knows, like, this is not true. But you've got to conduct the investigation and take it seriously. And I know it takes time away from HR, the management, when you're trying to, treat patients and residents and take care of folks and your employees, but it will save you a huge headache in the long run. So do your investigation, come to your conclusions, document, your steps. And when you get back with Martyr Mary does not need to know the exact, let's say that someone was breaking policy. Martyr Mary does not need to know the personnel decisions that are made with regard to other employees, but what Martyr Mary should be advised of is that her complaints were investigated and the appropriate actions have been taken, and that, you appreciate her coming to you, and that if she experiences any retaliation by anyone that is against company policy, and for her to contact you immediately this way and document that. This way, if she doesn't and later says she was, treated badly because of the complaint that she made, or complaints, plural, that she made, you can have documented where you asked her to come to you right away if she felt she was being treated poorly because of the complaint. Okay. All right, well, I'm going to get moving so we can get on to the next personality, or the personage here. All right, next we've got, Paranoid Pat. Poor Paranoid Pat. Paranoid Pat is very suspicious. Everyone is always out to get Pat. Well, in this case, Pat has made, Pat's very hypersensitive to comments. So Pat has made quite a few generalized complaints. And when I say generalized, I mean they're vague. They don't really implicate like anything in particular. They don't, you wouldn't be thinking that there's an anti-discrimination law you need to look at. And my favorite here, and I'm sure you all have probably heard this, is this is a hostile work environment. Well, that is not a legally protected complaint. Of course, you want to ask Paranoid Pat why Paranoid Pat believes that the work environment is hostile, because then you'll get the answers, and that answer might be a protected complaint, because of, my gender or race or age or some other protected category. But you do need to follow up with why the person thinks it's hostile, because sometimes they just say, well, my supervisor is, just rude or mean. And then, do they treat, you ask Paranoid Pat, does that person treat others that way? And yeah, it's just rude to everybody. Well, an equal employment an equal employment opportunity harasser, or, is different than, someone who's actually discriminating or harassing someone based upon a protected category. So, this is also generalized complaints are also someone that says things like, false allegations have been made against me, or I'm a victim of abusive treatment by the manager. Those are, what the courts say in case law are called petty slights, meaning, it's boorish behavior, but it's not illegal. So I would ensure that no bullying is going on, and that there's not any sort of, violations against company policy, but Paranoid Pat would not be making a protected complaint. All right, let's move to Narcissist Nancy. Oh, it is the Nancy show all day, every day. Nancy is arrogant. She's always right. She has a sense of entitlement. She's usually a long-term employee. And Nancy, in this case, loves to talk politics in the office and loves to get everyone riled up because she is always right about her position. Well, this, of course, starts fights, but starts arguments, could start a fight, you never know, in the workplace. So this hot button issue is relevant today because we actually see these types of issues crop up with our clients. So, you know, private employers, you can place restrictions on, you know, a person's political discussions in the workplace, but that's, you know, I think the better practice would be to look at it from a morale perspective, you know, morale of employee perspective, and monitor the issue of whether someone is violating the company's conduct policies or anti-discrimination policies. So it's a good time to remind employees that, you know, that the company does not tolerate any comments derogatory related to, you know, age, gender, religion, national origin, and if those policies are violated, that the person will be, you know, subject to discipline up to and including termination. So you've got to really enforce those, because if one person gets a pass and the other person doesn't, then that will cause problems for the employer later on. So, you know, you just want to make sure the treatment is consistent. And there is one thing that I wanted to just bring up briefly about politics. There are, the NLRA, you know, is always, the National Labor Relations Act is always hanging out there, and it applies to private employers as well as those who are non-unionized employees, as well as those that are unionized. And if there is a ballot measure regarding, you know, something like minimum wage, you know, the NLRB would look very unkindly upon an employer trying to, you know, stifle an employee's speech about the terms and conditions of their employment. So that's something to look for when we're talking about politics. But with narcissist Nancy, she may always be right, so she thinks. And when you meet with her, you've got to be clear with her and with those persons that decide to engage. Number one, it's, you know, it's a disruption to their job. I mean, it could be on their break, but still, to really make sure that they don't cross the line into the area of, you know, potential discipline because of their conduct. Okay, got a few minutes left to talk about, let's see, Dougie Downer. Oh, poor Dougie. The glass is always half empty with Dougie. I'm sure you all know some of these Dougies yourself. Poor Dougie, he gets sick really easily. And in this case, Dougie has gotten sick so many times in the past. He's a frequent FMLA user, and his FMLA has always been granted, but he just is a sickly person. So Dougie is sitting in the break room with his with his coworkers, and this is when he's back from his third FMLA leave. And he goes to the refrigerator and he opens it, and he gets really, really upset. Someone has used his half and half yet again. And, you know, his friends and employee or co-workers are sitting around the table, and, you know, they're like, one of them pipes up because they like to mess with Dougie and says, you know, first of all, how do you even know? And second of all, you know, you can use mine when I'm out, you know, it's just a teaspoon. And so Dougie, you know, he drew a little line on his carton with his pencil. So he knows that someone's used it. So the employee that wants to antagonize poor Dougie says, you know, okay, fine. I used your stupid half and half. Here's a quarter. Well, that really, really ticked off Dougie. So Dougie stood up, pushed his chair back with his legs, and said, I am going to shove that quarter up, and then you get the rest of it. Okay, so another employee complained to HR that Dougie was about to engage in some workplace violence. So long story short, the investigation went underway. Dougie was interviewed, as well as all the witnesses in the break room, and Dougie ends up getting terminated. So Dougie brings a FMLA retaliation claim. Here, we're going to skip all the way to trial, and or before we even get to trial, summary judgment, let's say. The employer wins on summary judgment because the court found that Dougie consistently used FMLA 3 times in a few years without issue. His shifts were always covered, and the company had granted FMLA leave for, 34 employers in the last, 3 years. So here, what you've got is you've got to make sure that Dougie would be treated just like anyone else who engaged in workplace violence. He hadn't had previous discipline before. So even though the termination was, let's say it was 2 weeks out, and that's very, very close, you have got you've done the investigation, you've done it well, you've documented it, you have witnesses, you have witness statements signed and dated, and you have proof that Dougie did indeed break your workplace conduct policy, and you've taken the same and consistent actions with others. Okay, oh my goodness, we're going to move to Carl, the casual complainant. So Carl gets along with others. He's a good employee, doesn't like to make problems at work. So, but Carl did complain that Dougie was getting extra breaks or longer breaks than him. He just kind of mentioned it. He wasn't complaining. He just mentioned it. So in this instant, Carl he's about the same age as Dougie. This was before Dougie got fired. And he's the same race as Dougie and the same gender as Dougie, and he's just really just complaining about something that is not an illegal action. So in this particular situation, so Carl, the casual complainant, you just want to ensure that Carl knows, if you want to make a complaint, please go to your supervisor and talk to them, because passive complaints and, these informal complaints, they're complaints also, and you should address them, but some of them can be addressed very, very quickly and not a long, drawn out investigation that some investigations actually take. But the key is to make sure that Carl knows the complaint procedure. Okay, next we've got Penny the pot stirrer. Penny is a gossiper. Penny is an instigator. Penny found out that some of her coworkers were having a Facebook party. She found out that they were having a Keeping Up with the Kardashians final episode party at her house. Not her house, their house. Penny, pot stirrer, was not invited. So on Facebook, she posts on Facebook that there are some of her coworkers at this party, and they sure are acting like the quote Kardashians. And so Penny posts this on Facebook, and then the next day at work, one of the employees that was accused of being a Kardashian, she sees that on Facebook through another employee who shows her, who's friends with Penny, and so this employee takes it to HR. Now, there can be many ways that social media off-duty conduct can be cause for discipline or termination. It is just like as if they're in the workplace, if they are violating your company policies. If Penny was making derogatory comments with regard to this employee and her national origin or, race or something like that. Penny here pretty much has just been, her complaint is pretty generalized. So, in this case, there wouldn't be a protected complaint by the employee that complained about being called a Kardashian. Now, if she complains, about a protected characteristic, or if Penny made some comment that led you to believe it was a protected characteristic, then that's a different story. But here, what we have on these social media posts is you want to get all the facts. Of course, you can't tell Penny to give you her password. You can't look over her shoulder while she shows you her Facebook posts. But if someone brings you something, you certainly can look at it. And also, you want to make sure that you look at the conduct and that it is work related and that it is not a protected concerted activity, which means that, you know, Penny's not complaining about the terms and conditions of employment, because then again, the NLRA has an issue with that. So that would be problematic. Here it is simply Penny being a gossiper, and Penny should be advised to, you know, to concentrate on her work, and that, you know, not to, just to make sure she doesn't cross the line. Stephanie, how many more minutes do I have?
10 minutes total.
Oh, 10 minutes total. Okay, well, I've got one last, I have one last personage. It's Ron, the reluctant reporter, and then I'll take questions. So Ron, he doesn't want to make any trouble. He's a good worker. He just wants to do his job and go home. And Ron is probably one of your favorites, as he would be mine. But in this case, Ron, he witnessed alleged harassment against another employee. So he's a witness. And he is named by someone else. He didn't come forth to HR. HR heard about that he was at the location of the alleged harassment. So he was asked to come into HR. So with someone who's reluctant to even talk about the situation or what they saw, you've got to be really direct, ask pointed questions, because they typically will say, I didn't see much, or, you know, I didn't really hear anything. Well, you've got to ask, you know, what did you hear? Did you hear this? Did you see this? And then very reassure Ron that he will not be retaliated against by anyone for just participating in an investigation. And if he is, or if he feels that he has been, to come to HR immediately, and you will take care of it, because the company does not tolerate a retaliation, and you appreciate his willingness to tell the truth about what he saw and everything of what he saw. And then of course have Ron write a statement, and then again, don't promise him 100% confidentiality. So, okay, so, oh, and then also, no news is good news is not a very good policy to go by. You want to check back with these folks who have made complaints or who participate in investigations to make sure there hasn't been any, they don't feel that they've been retaliated against, and make note of that for your files. Okay, so key takeaways before we get to questions. So complaints of discrimination do not guarantee job security. It may seem like that, and some employees make complaints in order to have job security. That is not the case. You just have to make sure that you have all your ducks lined up in a row, and that you've taken the necessary actions to address all performance issues in writing, training those supervisors to be consistent, and update your employee handbook, distribute it to everyone, have them sign and date that they received it. Enforcement of policies must be consistent. Communicate the reasons for the termination to the complainant. This is another big one. Instead of, oh, we're going another way, or going another direction, or this is an at-will state. Those are probably two of the worst reasons that I've heard, because what that tells the employee is, they are hiding something. And then their attorney, who they go see, really thinks the employee is hiding something. So just communicate those reasons. And then of course, those reasons need to be the same when you're talking to the OESC, the Oklahoma Employment Security Commission, the EEOC, and then in a lawsuit. All right, so Stephanie, do we have any questions?
Yes, Stephen has asked what forms of documentation are acceptable.
So Stephen has asked what forms of documentation are acceptable. If you mean documentation regarding statements, then the document, and I'll go to discipline as well, but if you mean forms regarding statements, it could be a written statement, which is usually the best, because that way the employee can just write it down right then. but it can be done on a computer. If you are referencing or referring to disciplinary forms or termination forms, if you don't have any that are readily made for your supervisors to complete, then it would probably be a good idea to have your employment attorney create some forms for you so that all the boxes are checked. And I say checked, and I don't mean just checked, but that there are reasons given and where the prior disciplinary action is listed, and the employee can sign, and there's a witness if the employee refuses to sign, and you can write refuse to sign and then write the date. So, you know, you should look at your employment or your discipline policies and make sure that they are in line with any forms that you make. Any other questions, Stephanie? All right. Well, if there, oh, one other question. Oh, you're welcome. And I hope that answered your question. Okay, Stephanie, do we have any time left? We've got 5 minutes. Does anyone have any questions? Yes, email is a form of documentation. That was a question. Is email a form of documentation? Email is a form of documentation. And I've seen a lot of emails that an employer relies upon as documentation. Now, when you do email, not only documentation of, you know, some employers, they're a smaller employer and they just don't have all those forms. And as long as the email is clear and written to, of course, to the employee, and the employee gets it, I would request a response that they understand and ask if they have any questions, because you want to know if that employee has any questions or comments so you can follow up on that. That also goes for the discipline forms. Leave some space for comments, because you want to be able to say later on, if the case went further, that, look, we gave that employee a chance to respond to this disciplinary action, and they did not. Here is, you know, sometimes they write no comment, sometimes they leave it blank. And that's really, really important in depositions if you've ever been in one, because the employee, you know, they're just like, you know, the lawyer says, you didn't have any comment, did you? I didn't. And that's usually a bad sign for the employee. So yes, email, and of course, watch the email communications internally between supervisors and HR, because many times, unless you are seeking advice from your lawyer, it is just, those emails are discoverable, and what you say will come back to haunt you one day. So watch the exclamation points and the emojis, and just try to make it as, you know, as benign and professional as possible. So any other questions, Stephanie?
We did get one from Anna. Do I need to document all conversations that an employee brings to me?
Okay, the question was, do you need to document all conversations that the employee brings to you? Well, you know, some HR folks would literally tell me, I'll be sitting there writing all day long. But you don't have to write them verbatim, but I would document, if you have that problem employee or that serial complainant, and you know, documenting the date and the time that they came to you with a complaint, and then you look into the complaint, and then you get back with them. And if their complaint wasn't substantiated, I mean, it could be something minor that doesn't take long to investigate. It could be something that takes long to investigate. Yes, I would document them. Document the conversations, and document what you did in response to those conversations, and document that you got back with that employee. This will save you so much time. I know it's a lot of time on the front end, but it'll save you a lot of time in the end, and save your employer a lot of money as well in defense costs. Hopefully it would stave off a lawsuit, maybe not, but at least you would be in a better position and have a stronger defense. All right, well, if there are no more questions, I am going to get you guys out of here on time. Thank you so much for taking this flight with me today. The seatbelt sign is turned off. Ha ha ha. You guys have a great rest of your day, and we will see you next time in our webinar series. Thank you, everybody.